Sean. Looks like next up is the executive committee meeting. And so if I could get staff's assistance with promoting the members of the executive committee into the the panelist category, that would be appreciated. And that will give me time to pull up the agenda. If you just let me know when everyone's in, I will call us to order. And Donna, I don't typically chair this meeting, so if you would do me the favor of reminding me who staffs executive committee, I know who to call on.
That's Dag.
Okay. Dang it. Just kidding.
Just don't call me Madam Secretary.
Yes, sir.
I'm seeing Broughton, Delenn. I'm seeing Bertula. I see Seleg, I see you, Vice Chair, and we have Trustees Stalling and Ganong will be, they're not members of the committee, but will be presenting on one of the items. And Trustee Cisneros, I believe we have our committee assembled.
Okay.
You could be the first dude.
Why not? It is just coming up on 2:25, which means that we are now 10 minutes late. And instead of blaming Justice Petru for jinxing us, I will blame Trustee Stallings for just taking too darn long and rad. But thank you, members of the committee, for joining us. Thank you, members of the public who are watching. We are calling to order the January 21st meeting of the Executive Committee of the State Bar. The agenda has been posted in accordance with law. We will shoot straight into the agenda. Do we take a roll?
We do.
Thank you, sir.
Broughton,
Here.
Cisneros,
Here.
Delenn,
Here.
Bertula,
Here.
Duran,
Here.
Seleg,
Here.
Hershkowitz.
Here.
All right. We have a
Great.
quorum.
We have a quorum. This is the portion of the meeting that is set aside for members of the public to comment on any agenda item or any item of business that would otherwise come before the executive committee. Mr. McLeod, do we have any members of the public expressing interest to speak?
I do not see any hands raised.
Okay. We will boogie through the meeting. Maybe we'll actually finish by 2:30. Doubtful. For the chair's report, I see that Mr. Seleg is on the line. I will not call on him to give a report unless he would like to.
No, thank you, Ruben. No
Okay.
report.
Thank you, sir. With that, there's nothing on the consent calendar. We'll move over to the first item of business, item 3A, the legislative priorities for 2021. Mr. McLeod, please.
That's my item. And as I believe you all know, the State Bar has a process now for soliciting input regarding proposed legislative changes that we would seek as part of a proactive legislative agenda for the State Bar for each legislative session. At the January meeting, we bring that proposed list of priorities to the executive committee and review it. The process, as I mentioned, is one in which we solicit input from State Bar staff. I'm going to note in advance that there is one item in particular that followed a slightly different process. And when I get to it, I'll talk a little bit about that process. And I am aware of the time. I'm going to speak quickly. I do want to make sure, though, that we talk about the specific issues on the agenda. There's an item, and I've bundled these, I've organized these, and they've been presented in this particular agenda item. as related issues rather than simply sort of following the Business and Professions Code in order. So the first item on the list of priorities is what I would refer to as strictly legislative cleanup. It refers to Business and Professions Code 6007C5, where it's clear that an attorney who is incarcerated must be incarcerated for at least the length of the term of incarceration, but it's not clear when an attorney who is incarcerated must be enrolled as involuntarily inactive for at least the length of the incarceration. It's not clear when that enrollment as involuntarily inactive ends. It appears to be an omission in the statute in that area of 6007 that allows for the involuntary inactive enrollment of attorneys. So this is a small piece of cleanup that the State Bar Court is seeking to clarify the end of an involuntarily inactive enrollment. There are two items that follow that were brought to our attention regarding debt collection, and I group these as one having to do with types of debt, seeking some clarification regarding a type of debt that is not specified in the statute, and as a result of not being specified in the statute is one that we are not currently able to seek collections on. It's monetary sanctions. We're looking to have monetary sanctions added to the list of types of debt owed to the state bar that we can collect on. The second category within that is refers more to types of debtors. Currently, the statute specifies that we can collect on attorneys who are publicly reproved or are suspended, but it doesn't allow us to collect on debt owed by attorneys who are in different statuses. So again, we're seeking to get some specification in the legislation that will enhance our ability to collect debt that is owed to the state bar. The next three items are tools for the Office of Chief Trial Counsel, tools in particular that enable them to get information that is commonly received by law enforcement that it appears to be implicit in the statute that they should get, but is not specified, and that has been difficult for them to get because they're not explicitly spelled out as having a right to that information. One of those pieces of information simply has to do with criminal history information, in particular police reports, toxicology reports, and the like. These things are sometimes denied to OCTC because they are not specified in the statute. OCTC is also seeking to get access to DMV records, in particular to photo IDs, which would facilitate their investigation of non-attorney unlawful, unauthorized practice of law work. And then the final area is to get access to telephone records that law enforcement has access to, but the Office of Chief Trial Counsel is sometimes denied out of confidentiality concerns because OCTC is not specified in the statute. The final item on the list of legislative priorities for the coming legislative session is the one that I mentioned earlier, that it followed a slightly different process. There is an effort underway by the legal aid community looking to expand access to services provided with funding from the IOLTA money to change the formula. And the legal aid community came to the State Bar, came to our Office of Access and Inclusion and the Legal Services Trust Fund with an interest in changing the formula to expand the eligibility criteria above 125% of the federal poverty line and take it all the way up to 200% of the federal poverty line. We think that this makes a lot of sense. We would like to engage with our stakeholders and support their efforts, and we view this as very much, it's a good partnership. It's something for us to be in lockstep with the legal aid community on and make sure that we're supportive of them on this. It's not really one that we're leading, but one that we want to make sure that we're getting board support for supporting. That's it for the priorities for this year. I do want to just make one final comment related to the 2021 priorities. We did make a point of including priorities that were part of our previous year's priorities, simply so that we wouldn't lose track of them. So although these are not things that we think are necessarily going to receive, we don't have a clear sense of whether the legislature will be engaged with these issues this year. They weren't adopted last year but we want to make sure that the board still has these as part of its, documentation of the priorities that we've had in previous years. So we included those legislative priorities from previous years, and those include our desire to eliminate the Governance Public Interest Task Force, the provision that requires us to assemble the Governance of the Public Interest Task Force every 3 years. We feel that that statute has outlived its usefulness. Maybe it's a victim of its own success insofar as much of what the task force was initially charged with doing has been accomplished, in particular the separation of the sections from the regulatory component of the state bar, and the final item being the separation of the lawyer assistance program into both a regulatory component, which the state bar would retain, and a voluntary component, which would move over to the California Lawyers Association. And I see that there is a hand raised. I apologize, I wasn't looking at that screen, but Trustee Broughton, I see that you have your hand raised.
Yeah, sorry about that. So what we're doing by this resolution, are we simply making this recommendation to the board for tomorrow? Is that all we're doing? Because there's one of the items on there that I don't necessarily agree with. So I think what we're doing is we're saying we would recommend all of these. And the one that I still have an issue with is that 1054.1, which is to require district attorneys and so forth to provide police reports and all of this information for attorneys that have only been charged. If you remember back when, probably Brandon's the only one here, no, or Sean, when this issue came up, I was the lone reasonable vote in voting against that issue because I thought there were due process problems with it. And so since I still don't agree with that rule, I don't necessarily agree with providing all of this information on charges only. So I guess my question is, if you vote to approve the resolutions, are you voting for each individual one to be sent to the board, or is it just for discussion?
We're seeking to have it approved to be approved by the Board of Trustees, and we have not unbundled them. So one way to proceed might be to take that item off, approve the slate that doesn't have any objections, and then bring the other item back to RAD for further discussion if we think that it needs to be vetted further.
And I would suggest, Mark, that you do that by a motion to separate that item out. And we can take a vote on that unless anyone else feels strongly, just so that the record is clear. And then, as Dag suggested, RAD would, I'm sorry, it would go back to RAD. Dag, is that what you said?
I guess you.
I
If I
think
made the
RAD would be
motion-
the right place to discuss it, yes.
Okay,
Well, if I made the motion to unbundle it, then it would have to be seconded. And if it was, we would vote on here to unbundle it or not, I guess, right?
that's what I'm suggesting.
And if it got unbundled, you'd vote on it. So it would just be voted on separately. So it could still pass and go to the board.
Correct. But your dissension and anyone else's, I suppose, who wanted to join you would be noted for the record.
Okay. Well, in that case, I would move to have that portion of it, which is on the bottom of page 3. It says 654.1 new, and then that portion of it there talks about the item. I would have that unbundled with the rest of it.
I will second the motion, Mark, but if you would allow me to maybe phrase it a different way, it might be to approve the legislative priorities as presented by staff with the exception of the item that you
There you go.
recommended, so that would be left off. Is that okay?
Yeah, oh, yeah.
Okay. Staff, are you clear on the motion?
I'm pretty clear. Are you not seeing my screen? I thought I was sharing screen, but perhaps I am not. So here's what I caught, and then I just want to make sure I've got the correct statute here. It's 6054.1.
Chair, if I may,
Yes, please.
I just want to make sure I'm understanding. If we unbundle them, are they both being sent to the board? I do remember Mark having some concerns, but I don't know that I'm ready to take a position. I'd like to have Melanie or Steve address it before taking a position on it.
I agree. So my intention was for this motion to take care of everything else And then what's left behind is 6054.1. On a separate motion, I would recommend that we refer that to RAD or the other appropriate venue for discussion and analysis.
So let me try one more time. I generally would agree with you. My concern sending it to RAD is that this is a legislative priority. We're already in mid-January. The legislative session is going to be starting, and I'm concerned that that's going to not get taken in a timely fashion.
That point is well taken. Dag or Donna, do you want to step in with some recommendations? Would it be possible to consider 6054.1 at this meeting? And maybe I should ask Mark as well to address Mark's concerns or questions, or just to have the debate.
I think we could certainly expedite the conversation with RAD and ensure, and we could do that either contained in the resolution or off, without putting it in the resolution, that we would ensure that it go to RAD within the next couple of weeks and be resolved.
Well, so let me suggest this option first in direct response to sort of how Josh phrased it. Melanie Lawrence, our chief trial counsel, is on the attendee side of this window. And so after we take a vote on the remainder of the proposal, if we then have this item left, we can ask Melanie for some insight. If that insight is sufficient for the committee, then the committee can take a vote. If it's not, then we can move forward to we can move to ask that RAD talk about it and expedite their discussion of it.
That makes a lot of sense to me. Mark, does that work for you? Josh, as well?
Works for me.
It does. I'm just not so convinced that after we vote on it independently, it can't just go straight to the board to have those discussions. But
I agree with you, and I think that's the next discussion we have after this vote. So the record is clear. The motion on the floor is to approve the legislative priorities as presented by staff, except for 6054.1, which we will take up after this vote. Is there any discussion on the motion? Seeing none.
Second.
Thank you.
So the motion is by Broughton, the second is by Pertula.
Yep.
Broughton,
yes,
Cisneros,
Aye.
Delenn,
Yes.
Pertula,
Yes.
Duran,
Yes.
Selig.
Nope. Sean will be
Okay.
voting.
Motion carries.
Okay, so that item having been bifurcated, as it were, 6054.1 is now on the floor. Mark, as the proponent, do you want to tell us what the concerns are, and then hopefully Melanie will have been promoted as a panelist and we can have a discussion.
well, again, I won't reiterate my concerns that I had about the original vote on 6101B. But this to me is a little bit different because according to the interpretation, at least of Steve and Melanie, about that rule was statutory and we didn't have any ability to object to it. I tended to disagree a little bit with the interpretation of that, but be that as it may, we passed it. This one, however, goes a little farther because it's requiring information that I, of course, deal with all the time, that is just full of all kinds of innuendo, if you will, and things that are unsubstantiated. And it's not required by the statute to be produced. So to me, it goes even farther than the original statute in sort of denying due process rights to a licensee who has not been convicted of any crime, is only charged with a crime. That's the way I read this. So I really have a problem understanding that we're all trying to protect the public. But again, the effect of simply an allegation against a licensee or an attorney, even if it's proved to be false down the road, can have devastating effects on that person's career. So that's on balance, that's why I would oppose at least pushing this legislation.
Thank you, Mark. I see Sonia has her hand up. Sonia, do you want to address what Mark said, or do you want to let Melanie do it first?
Melanie first. I just have a quick question, not
Okay.
being a non-lawyer.
Okay.
Sorry. Well, so I'm sort of ill-equipped. I just started looking at the proposal. The issue really is that we have to prove facts and circumstances surrounding any conviction. I think, is Steve in this room? He says he just entered the room. Does anybody see him?
And that's the problem. You're talking conviction. This is not talking conviction. This is
Oh, there he
talking
is.
charges.
Sorry. Yes. I think I just saw him. I'm
He's
gonna throw it to him because I think he might be able to shed some additional light.
Sure. Hi. So I apologize, Trustee Broughton. I heard just the tail end of your statement. I do agree with you that what we're talking about is giving the State Bar information that is not necessarily at the conviction stage. It is at charging. The issue is that oftentimes, we may not learn about things until after, right, through the conviction at the through the rap sheets, et cetera. We may have trouble getting the information at all. It's not necessarily that we are looking to do something else with this information other than following a conviction, right? This is to aid us in a conviction matter, which is only applicable following the conviction. It's just, as Melanie started to say, that we have to prove the facts and circumstances of the offense in order to demonstrate whether it constitutes moral turpitude or other conduct warranting discipline. And in order to do that, we often need the underlying police reports. And at this point, what happens is that we turn to the district attorney's office, and we generally are talking to some, a misdemeanor line deputy, and we have to essentially convince them, number one, that they've generally heard of the State Bar because they're an attorney, but they don't really understand what it is that we do, that we discipline attorneys, that we are involved in conviction matters and things like that. Or we have to go to the law enforcement agency, who sometimes has those records as well, and they generally say, oh, this is confidential, because they are confidential in the sense of they are not subject to a Public Records Act request, et cetera. But this is not looking to expand the scope of what we are currently prosecuting attorneys for. It is simply seeking to ensure that we have adequate records to prove the cases that people are already expecting us to prosecute.
So what I hear Steve saying is that the proposed amendment could direct the prosecuting agencies to provide the requested information, evidence to the State Bar following a conviction, right? Because Steve, you're suggesting that we're not looking at it, we're not acting on it prior to that.
That's not the way I read that, and that's my objection to this. And Steve and I went, at this tooth and nail a couple of years ago.
Right. That's why I'm suggesting we could word it that way, if that's consistent with what Steve is saying.
Yeah, no, I mean, I think we could certainly do that. Right now, what we do is we set up a conviction monitoring. We have a team of people a small team of people who monitor cases pending in Superior Court. And so rather than delaying the transmittal of that conviction by then having to go back and ask for these materials at that point, there's some logic, I think, to getting it when it comes to our attention and when the documents are most fresh. But yes, there's no reason that we couldn't change this to say following conviction.
But it wouldn't be attached to this particular rule. What is it, 6101B? That's the one, I believe, and the way this is written, that has to do simply with the attorney that's been charged, not convicted. You'd have to change the whole thing to say, I'm ordering the DAs to give all that information to us upon conviction of the person.
No, I think that 6101B could stay the same because they are just giving us notice that charges are pending, which is what their current obligation is. Frankly, we don't get a whole lot of notice from district attorneys' offices just because the only way that they would give us notice is if they know that the person is an attorney, which unless they appeared in court with them yesterday, they may not know. Or, you know, if the person got out of the car and said, you can't pull me over, I'm an attorney or something like that, right? They just wouldn't necessarily know that. So we don't necessarily get a whole lot of notice from them anyway. This is really meant to address a separate issue.
Thank you, Steve. Thank you, Donna. Sonia, do you still have a question?
No, I was just going to ask if we can, limited information, but now no, thank you.
Okay, Josh, your hand went up, but then it went down.
It went up confused and then it went down more confused, so that I wasn't even able to create a question out of it. I believe I understand Mark's position, and I find it compelling, and I'm not understanding, Steve, exactly why we would need any of the information pre-conviction. It would seem to me that I think your argument was that just makes us more efficient and we're ready to move forward. But if that was the argument, I think I would side with Mark that it's just outweighed by the unfairness of it. And so I'd be more than happy to support post-conviction, but without a better explanation, I don't know that I could support it either.
Yeah, I mean, I certainly understand where you're coming from, and I recognize that that's a concern. What I was trying to articulate before is that, and maybe I did, and it was insufficient, which I can accept. But what I was trying to articulate before is that we have, upon receipt of the certified record of conviction, we have now 30 days. It used to be 5. We now have 30 days to transmit that case to the review department. The review department will then review that. Oftentimes, we need additional facts and circumstances to make a recommendation to the review department or to complete the transmittal to say whether it is moral turpitude per se, whether it's moral turpitude based on the facts and circumstances, or whether it is other conduct warranting discipline. Without that underlying police report, without the underlying whatever, it often makes it difficult to make that determination. So it would further delay our ability to transmit within the statutory timeframe, number one. And number two, even assuming that we can transmit without that information, if we then have to wait until after we transmit in order to request those documents, you heard the state bar court this morning that cases have a certain time frame that they must proceed in. And so C cases or conviction monitor or conviction cases have to proceed. And I may get this wrong, but I want to say it's 125 days from the day of filing, they're supposed to be in trial. Well, if we don't get that discovery quickly enough in order to provide it to the respondent fast enough, then we're going to end up with a problem of proof later at trial. And so it does create some issues, but at the same time, I recognize the concerns that you raise.
I don't want to get too far in the weeds, but I mean, we're talking about legislative changes, and maybe I'm just too naive here, but I mean, based on the facts as you laid them out, won't the legislative change maybe be to extend the 30 days?
We recently extended it from 5 to 30, and that's, I think that was about the limit that they were willing to go. That was just for the transmittal issue. I will say that I don't think that this particular aspect was part of that discussion. I'll leave it there. I don't think that this piece was part of that.
Thank you.
Jose, were you wanting to speak? Sorry. Before I go, anyone else have any questions or comments on the interchange we just witnessed? Steve, you mentioned that after the receipt, part of the transmittal is in discovery to the respondent within that 30 days. Did I get that right?
We have to transmit within 30 days of us receiving a certified copy of the record of conviction. We have to transmit to the review department. And it's not jurisdictional. It doesn't invalidate our ability to move forward if we don't, but nonetheless, it's important. And so we have to transmit, but part of that transmittal includes a statement of our part, whether it is moral turpitude per se, moral turpitude based on the facts and circumstances, or other conduct warranting discipline. And it is without the facts and circumstances, it's very difficult for us to make that determination. We have also been limited in the past where we have said it is other conduct warranting discipline, from then later saying it is actually moral turpitude based on facts and circumstances, because we are told that we have transmitted it in one way. So it's important for us to have all that information, or at least as much as we can, at the time of transmittal.
Okay, thank you. Well, this is still at the executive committee, and it would have to go up to the board for final action. Does the committee feel like it has enough information based on what just transpired to make a recommendation to the board? Do you want to put it over for further review, perhaps by Rad?
Well, I'm not convinced, let's put it that way. I would I vote not to approve the resolution on this based on what I know about it, the way it's written. If it were specifically related to convictions, I understand Steve's request there, but again, when it's only 2 allegations, that's problematic for me.
Chair, I'd like to make a motion to send it to Rad for a little more clarification so that it can be studied a little more.
The motion is on the floor. Is there a second?
I'll second.
Okay. Any discussion on that motion? Okay, let's take a vote on the motion to send it back to Rad.
And I'm going to need to clean this up a little bit, because this is not a proposed amendment to 6054.1. It's actually, I think, a proposal to create a 6054.1, which would be added to 6054.
Okay.
Can just say the proposed addition of 6054.1.
Thank you, Doug.
Does that suffice?
Yep.
And I'm sorry, I didn't catch who moved.
It was
Josh.
moved by Josh, seconded by Mark.
Broughton,
Yes.
Cisneros,
Aye.
Delenn,
Yes.
Pertola,
Yes.
Duran,
Yes.
and the motion carries.
Okay. Thank you, everyone. Melanie, Stephen, thank you for jumping in with some good information. Brandon, this goes to you, buddy. What's next?
I would also note for the record that the 10 minutes you blamed on Rad was actually a 10-minute break designed for the convenience of the vice chair, in addition to everybody else, but I'll leave that.
Duly noted. Okay, so that was the legislative priorities item. We're on to 3B, Lawyer Assistance Program Oversight Committee, appointment of member. Christine and Brandon, please.
Christine, present on this.
Good afternoon, Executive Committee. This item presents the candidate recommended for the appointment to the Lawyers Assistance Program Oversight Committee to fill one position that is vacant as of December 31, 2020. So the Lawyers Assistance Program is also known as LAP or LAP, but since there's so many abbreviations, I would just not use the abbreviation. The committee oversees the operation of the Lawyer Assistance Program, LAP, as necessary to establish policies, practices, and procedures to support the goal of offering education and rehabilitative programs to attorneys, former attorneys, state bar applicants, and law students suffering from substance abuse and mental health disorder. So this committee has a prescribed number of members with different categories. So pursuant, and it's statutory. Pursuant to statute, the board appoints 6 members to the 12-member committee. By statute, the 6 state bar appointments must include 2 members who are licensed mental health professionals with knowledge and expertise in the identification and treatment of substance abuse and mental illness, 1 member who is a physician with knowledge and expertise in the identification and treatment of alcoholism and substance abuse, 1 member of the board of directors of a statewide nonprofit organization established for the purpose of assisting lawyers with alcohol or substance abuse problems, which has been in continuous operation for a minimum of 5 years, and 2 members who are lawyers, at least one of whom is in recovery and has at least 5 years of continuous sobriety. Currently, all board appointed positions are filled. However, on December 31, 2020, one of the positions became available because the term of Dr. Philip Spiegel, the physician with knowledge and expertise in identification and treatment of alcoholism and substance abuse, his term expired. So the recommendation of the staff is to reappoint Dr. Spiegel for another 4-year term to continue that role for that specific category. The majority of the Lab Oversight Committee members were appointed in 2020, making Dr. Spiegel's experience and perspective on committee especially valuable because he's one of the more experienced member of that committee. Dr. Spiegel is aware that the State Bar may continue to pursue legislative support for the transition of the LAP to the California Lawyers Association. At such time as that transition occurs, the LAP Oversight Committee of the State Bar will sunset. Therefore, although he is being recommended for another 4-year term, his term may only extend for 1 year, depending on what happens after if the Oversight Committee State Bar sunsets. So on that note, I believe that there is a recommendation for the Executive Committee to recommend the reappointment of Dr. Philip Spiegel for LAP.
Thank you, Christine. Members of the committee, are there any questions for Christine on Dr. Spiegel? Okay, seeing none, I'll entertain a motion.
Also move.
I second.
Thank you, Jose.
Moved by Cisneros, seconded by Delenn. Broughton? I'm sorry, did Broughton respond?
He did, said yes.
Cisneros,
Yes.
Delenn,
Yes.
Petula. The motion carries. Vice Chair Duran, I'm sorry, we typically don't have the chair vote. I had you vote in the first couple, but I shouldn't have. So
I just considered it a bonus. Thank you.
all right, thank you.
Item 3C is, oh man, I just closed the agenda. Sorry about that. Oh my goodness.
I think.
Go ahead,
I think
Dag.
Brandon can speak to that because I think we have an easy solution on 3C.
Okay, good.
I don't know what the easy solution is, but hopefully it's a quick presentation, so I'll do my best. So
we discussed the possibility of tabling it because this is it's the full ad hoc commission appointments. These are not normally on they're not normally on the discussion agenda of the Board of Trustees, but this one is on the full discussion agenda of the Board of Trustees, and as a result, felt it was redundant perhaps to have it on this agenda as well.
Without objection, we will table this item. Okay, I got my agenda back up. Item 3D is the committee work plan. Mr. McLeod.
The Board of Trustees began bringing to the Executive Committee work plans of the Regulation and Discipline Committee, the Finance Committee, and the Audit Committee for approval. so that we can ensure that the work of the committees is aligned with the strategic plan and that the committees are accountable for the work that they're doing. This item follows that same practice and has as an attachment the work plans of each of those committees of the Board of Trustees.
Thank you, Dag. Members of the committee, any questions for Dag on the work plans presented? And no discussion? All right, seeing none, I will entertain a motion, please.
I move.
Motion
I'll
by,
second.
second by Cisneros.
Broughton,
Yes,
Cisneros,
Aye.
Delenn,
Yes.
Bertula,
Josh left the meeting, sorry about that.
I'm going to ask for your vote because we have 3 out of 6 members voting, although, so I'm going to ask for your vote. Duran,
That's a yes.
and the motion carries.
Thank you. Okay, that takes us to the adjournment. Thank you, members of the committee. Looks like next up is the full board meeting.